Ladies and gentlemen, please welcome CEO of Churchill Club, Karen Tucker.
Hi, everybody. Welcome. My name is Karen Tucker, and I'm CEO of the Churchill Club. Our program tonight is called The Privacy Gap. Each year, we are proud to work with our program partner and sponsor of this event, the Microsoft Trustworthy Computing Group, to present a new discussion in support of Data Privacy Day, which in and of itself is about making people and groups aware of privacy and data protection matters of import. This happens every January 28th. And each year, the Trustworthy Computing Group commissions research to better understand people's online privacy perceptions and expectations. And this important work gives us insight into the most up-to-the-minute way to frame the discussion most appropriately. We're privileged to have with us a remarkable group of speakers: Laura Berger, Pam Dixon, Brendon Lynch, John Potter, and our moderator, Chris Kelly. Welcome, and thank you all very much for being here. A brief introduction for our new guests in the audience. Churchill Club is the top independent forum for business and technology discussions in the Bay Area, now in our 28th year. And what drives us every day is to encourage innovation, economic growth, and societal benefit. We do this through the up to 40 programs that we present every year, where like minds can learn and connect with one another. Our next program will be held on January 30th, as we take a look at software-defined networking and explore the question, is it the next networking revolution? This is in San Jose at Ericsson. On February 7, we present LiveOps Chairman Maynard Webb in conversation with eBay CEO John Donahoe. They're going to be talking about a new era for work that's also in the South Bay. And on February 11, we're going to be talking about building trust in 2013 with a group of very accomplished, interesting thinkers, and this is at the Four Seasons in Palo Alto. We hope that you will join us for at least some of these programs. If you are tweeting, please use the hashtags Churchill Club and DPD13. You'll find other Twitter codes in your printed program. And finally, the wireless access code is DATA13, D-A-T-A 13. Let me now introduce our conversation leader. We'll then ask the other speakers to self-introduce. Chris Kelly is a very well-known figure in California and especially the Bay Area. As Facebook's first privacy officer, general counsel, and head of global public policy, he helped build the company from its college roots to a service for everyone. And after being there for 4 formative years at Facebook, he took leave to run for Attorney General in the state of California. Most recently, he founded the Safer California Foundation, where he works to protect Californians from all forms of criminal exploitation. And he also is an investor and works with web-based startups in particular. Please give your warmest Churchill Club welcome to Chris Kelly.
Thank you very much, Karen, and thanks to all of you. I want to start with a couple of stories, and then I'm going to ask a question of you, the audience. The couple of stories, first of all, about the Churchill Club. What a nice introduction, but I was able to reminisce a little bit with my friend Matt Zinn, the general counsel of TiVo, about the first Churchill Club event that I ever went to when I came back to Silicon Valley in 1998, after growing up in San Jose, was the TiVo Replay TV. It was the future of TV. And still today, the future of TV is being developed and poses lots of privacy questions. But also the story of the unnamed chief privacy officer in the room who checked in here and showed up on my Facebook as being nearby. Interesting things for us to think about. And also, what I want to ask of all of you is, we just talked about the ability to tweet and use Twitter hashtags. When you were told to silence your phones, how many of you turned them off? One. So this is what happens these days. There was once an event that I went to with Chris Garvin, the CEO of Motorola, who said at the beginning, he says, I want you to turn your phones on. And that's what's happening these days as we think about privacy and data and the discussions that happen. We have all of these devices that are constantly talking to networks and communicating, and in most cases we want that. But in a lot of cases in all cases we want some control over it. And that's fundamentally what we end up with in this privacy discussion. The question of how to do that effectively is what the topics that we'll run through tonight. So with that, I want to turn to each of the panelists to give a brief introduction of themselves and of a little bit of perspective of what they bring to the app debate and how apps are working and how we more effectively provide privacy knowledge and protection to consumers. So I'll start to my immediate right with John.
Thank you, Chris, and thank you, Karen and Churchill Club, for having me here. I'm John Potter. A year ago, I founded the Application Developers Alliance. In that year, we've acquired 20,000 individual developer members and 125 companies, ranging from 2 and 3 and 4 person companies up to Google, RIM, AT&T, CBS Interactive, and folks like that. So we sort of span the spectrum. We have been very, very engaged in the mobile app privacy discussions. We've worked with Pam Dixon and Consumer Action and the ACLU to forge what we think is a middle ground. I think it's, for those of you who are engaged in privacy and watching the Department of Commerce and the NTIA debates, and in many times they're bomb-throwing, flame-throwing, like crazy stuff. Like, I'm not out of the privacy world. There's some personalities that are really remarkable. And I work with Tim Sparapani, who used to work with Chris at Facebook, and I said, Tim, there's got to be a better way. And we spent several months locked in a room with 3 consumer groups saying, we don't have to be part of that, sort of air war. We can find a coalition of the willing and a middle ground that will both help consumers and promote innovation. And so we've spent many months doing that, and we're really pleased with how that's going.
Great. Brendon?
Brendon Lynch. I'm Microsoft's Chief Privacy Officer. And thanks to Karen and the Churchill Club, we're very honored to partner on this annual event that we do around Data Privacy Day timeframe. My role at Microsoft is, like many Chief Privacy Officer roles, has accountability and responsibility for our privacy program, where we ultimately set and implement policy for the company to ensure that we're upholding key principles around privacy for all of our customers. And also, increasingly, we're working on a lot of innovation areas around privacy, trying to bring forward meaningful controls to both individuals and organizations to better protect their information, as well as doing increasingly a lot more engagement externally, given the breadth of, I think, of the people that would call themselves as stakeholders in the privacy discussion seems to be growing all the time, and Microsoft, with a very diverse portfolio of products and services, seem to come into a lot of these discussions, whether it's online advertising or mobile or cloud computing or anything else that is a hot topic these days. So that's a lot of what I spend my time doing, as well as also looking to the future to see where do we see technology and data going, and how does privacy need to evolve to work well in the future as well. Pam.
Hi, I'm Pam Dixon, the Executive Director of the World Privacy Forum. I am basically a geek and really interested in privacy issues as they intersect with how we live in a digital world. I founded the Privacy Forum about 10 years ago because I was incredibly intrigued with some of the issues I had been researching with Richard M. Smith, who some of you may or may not know, a really well-known security and internet guy. So once hooked, I really took the bait and just really became very active in looking at health privacy issues, various identity and biometric issues. And of course, this mobile application issue has been some of the work that I've ended up doing quite a lot. When the Department of Commerce announced that they were going to have this multi-stakeholder process, I actually held a meeting with all of the consumer groups and invited everyone, and we all got in a room and said, this is going to be a disaster because there were no rules. So we tried to formulate some rules of the road, which were written and published and promptly ignored. So we got in the room, and basically it was basically what I would say is this. rage is a really bad way of making public policy. So we were really happy to find a way forward, and we're really interested in finding where the middle ground is in privacy, a place where really, really good policy is made, and that's a very difficult thing to do. And it's actually, surprisingly enough, we've actually published a lot of very critical reports about self-regulation. And typically what's been done in the past is privacy self-regulation has been done only by industry, locked up in a room by themselves. This mobile app privacy initiative is actually the first time where civil society and industry have worked together to find a middle ground. And I think we're all really proud of our efforts and very hopeful. So it's been a really, really good experience. I think a good outcome too.
Great. Laura?
Hi, I'm Laura Berger. I'm an attorney for the Federal Trade Commission. We actually have a division devoted to privacy, and I'm an attorney there enforcing federal laws to protect consumer privacy. For anyone who may not know, the FTC is an independent agency based in Washington, D.C. I happen to be based out here. And you'll probably hear me talk about a number of different areas of our work that relate to privacy, maybe 4 things in particular. So we do quite a bit of, and these are not at all in order of importance, these are all important parts of what we do, but we do education and outreach to businesses. So we recently developed a guide for mobile app developers called Marketing Your Mobile App, Get It Right from the Start. We also do law enforcement, and I'm sure we will touch on a number of things that we've done relating to the practices of mobile apps and other online types of companies. We do some rulemaking, obviously where we have authority. We cannot just up and make a rule. Congress has to tell us that we can make a rule, but we recently in that area revised our Children's Online Privacy Protection Act rule, the COPPA rule, and the revised rule will take effect this summer. And lastly, of course, we also have been involved in the policy area as well. We had a guide for businesses and lawmakers, a privacy framework that we finalized in March after a series of roundtables and a proposal that had very widespread participation. Another recent example in our kind of policy making and debate fostering role, we have a mobile tech unit that has done a couple of very illuminating reports on the privacy practices of kids' apps that you might have read about, and I hope we have a chance to discuss these things more. So thank you to the Churchill Club for hosting this.
Well, I mean, this is a fantastic panel. I want to start with the notion that for this panel, at least, there may be a broad range of agreement about consumer empowerment and knowledge, and that being the object. The hard problem for this panel, and again, then there are some folks who do think that snarfing up a bunch of user data is an acceptable business practice and the way to go. I wouldn't characterize anybody up here like that. The question is how to effectively go about this. So how do we move forward in a number of ways? And John, I know that you've got a model that's being worked on at this point. So why don't we start there?
Sure, thank you. Let me start by saying I'm not a privacy guy. I'm not a CPO. I've done a lot of other things. But the last year has been my first year of playing the privacy game, and it's been fascinating in many ways. I am a huge believer in consumer choice and letting consumers make their own choices and having them be informed choices, which is why one of the reasons we embraced the Department of Commerce NTIA process about mobile app transparency. I also think there's the whole idea of privacy is a quirky word. We have surveyed consumers, and well over 60%, closer to 70%, are very comfortable sharing their data. It's not about, or giving their data to their app, to the website, to whomever they're doing business with, right? They have a relationship. And in fact, we think a big issue, which is not really on this agenda, is about data breaches as opposed to data collection. So the issues are, what are you collecting? What are you doing with it? Who are you sharing it with? And then, by the way, have you had any breaches lately? And what's the downfall of that? So I'm going to take the extreme position for a minute and say that I personally would take the position that if I say to a consumer, I am collecting every single piece of information about you, your birth date, your social security number, your children's names, whatever, but I'm telling you this up front, and you choose, smartly or not, to continue to use my app, that's an educated, informed choice, and consumers have the right to make that choice. I think there are some in the community, in the stakeholder community, that don't believe that. And that's where, one day Pam and I may disagree, or some of the consumer groups and we may disagree. But I'm a huge believer in effective communication about what we're collecting, who we're sharing it with, and then we get into sort of, can you actually effectively and efficiently say why it's being shared and what's being done with it, and that's a harder issue. So I would just say, as a starting point, if we can inform consumers efficiently, we're collecting your precise location, your birth date, your gender, little stuff like that, and they feel like, oh, they know, okay, now that I know, I can make a choice. That's a huge step forward, I think, from where regulators and consumers and stakeholders generally feel like we've been.
So Pam, that sounds eminently reasonable. What are the problems with it? What does it miss? How do we further that discussion?
Yeah.
Okay, so
I say that saying that, so knowing that there are some problems with it.
I like smart people. I think that discussion only does good, and I think that, okay, so one of, I think, my biggest tasks is to reimagine privacy in this modern era, because although I may have started many years ago with the idea that analog privacy could somehow be transferred to a digital era, I was incorrect. And I have realized that just over and over again. So I think of privacy in this way, and I think this will somewhat address some of your comments and just kind of add to it, and definitely address what you asked. Okay, so I think of privacy as a continuum. Privacy is not an either or, and I think it's a real mistake to think of it that way. Either you have privacy or you don't is really kind of an old way of thinking about privacy. It doesn't quite work in a digital era, so I prefer to think of it as a continuum. So there are building blocks of privacy, there are nuances, there are stages, and there are gradations. And I think it's really important to determine what's important, what's really important. A good example of this is, for example, the difference between facial detection technology and facial recognition technology. In facial detection technology used in, for example, supermarkets, you're not storing images of people, and it's not being used for anything. In facial recognition technology, it can be used for all sorts of mischief, and it's a whole different ballgame. So it's a different continuum. The other thing I would say is that beyond privacy being a continuum, I think it's about a new definition of privacy. In the past, privacy has been thought of as a way to keep a secret or to avoid a harm. And I think that these definitions are a subset of privacy, but a better way to think of privacy in this era is to think of privacy as control. How can we shape our digital destiny? How can we shape the information that we know is percolating, that we've either created or touched or in some way relates to us? And that's a really different way of looking at things. So control is also very important. And then a third area I would bring out is convenience. In so much of my work, I have encountered this idea on the innovation side that privacy is a bummer. It is just awful. Privacy is the thing that gets in the way of us doing what we want to do. And if people innovate with that idea in mind, the way that percolates down to the consumer is that the consumer ends up with a product that's enormously inconvenient and kind of a bummer for them to use. So it's like just wrong all the way around. And I think the way to get around that is to do the above 2 points, which is, okay, privacy is a continuum. We don't need to do it all or nothing, not all at once. privacy is about control and not about, making everything completely secret, and also making sure that there are certain, rights and parameters. But I think that also to find a way that privacy is something positive and not a barrier, something to compete with, something to view a little differently. The place that I've seen this play out the most is in health privacy. There have been a number of proposals made at the state level that have tried to reduce, for example, privacy given to AIDS patients or to people who have genetic illnesses. And the reason was because privacy was a barrier to the adoption of health information technology. And this is the wrong approach. I think there's a better approach, and that is, okay, here's a challenge. How can we make this more convenient for us and for the patient or consumer? So
Brendon, how do you design products that meet those types of goals? How does a large company like Microsoft or smaller companies begin to think about that?
Yeah, I will answer that question.
Mm-hmm.
But I
Great.
first wanted to come back on just one.
Everybody wants to respond to John.
Yeah, exactly. Because John put forward, I think, a very simplistic in some ways, model that consumers should be in control and make every choice. And to some extent, I agree, but to other extents, I don't. And the reason being, there's kind of two reasons. One is that there was a key phrase he used was effective communication. And it's very difficult to do that today. And I don't think consumers really want to spend the time to read the statements. They necessarily, to make those informed decisions. Many consumers just want to move on, get the value of whatever the app is, and just be safe. And so they're really just looking for a level of safety and protection. So there are some things you wouldn't expect to need to have to ask them. For example, you shouldn't have to, an online retailer shouldn't have to ask the consumer, is it okay that I share your delivery address with UPS? Because there's an expectation that that'll just happen. So you could overburden people with choices. At the other end of the spectrum, offering a choice of, can I use your DNA to discriminate against you for employment reasons? I don't think that's a fair question to ask anybody, and we've got a law that prohibits that sort of thing. So at the other end of the spectrum, there's going to be certain uses where we just don't sort of have there. But I think that the key is coming back to the spectrum idea a bit, that people are at different levels in terms of how they value privacy, how much time they want to spend doing the reading and making these informed choices. And others just want to be safe, and we need to cater for all of those. The way that we think of it, to tie it back to your question, the bridge, is privacy by design. And what we mean by that is thinking about privacy right from the inception point of a product or service and following it through its development cycle and into production to make sure that it lives up to what we strive for. And that can be a combination of things, which is to make sure that there is effective notice and effective communication about what the product or service does, to make sure that there are meaningful controls. But often it's also a matter of choosing appropriate default settings on behalf of users as well, because some of them, it's pretty clear where they want the default to be and to choose that. And the other thing I'd say while I've got the floor is that this research that Karen mentioned earlier actually illustrated to us, we can share the details, but broadly speaking, there was about 45% of the people we surveyed said they don't feel in control at all about the collection and use of their personal information online. Many of them don't really know how to protect themselves. A lot of them do try and look at privacy statements, but they also are asking friends and family and trying to get advice. And there are a lot of people really struggling with this. But there was an interesting stat as well, which I think is informative for people in the space, which is that people are increasingly taking privacy reputation into account as they're making these trust decisions. And at least they say they are. And I think that's really important to understand too, that trust can be, and privacy as a contributor to trust, can really inform buying decisions or adoption decisions here around the use of technology.
So, Laura, you get to see a lot of these situations when things go wrong, when a consumer has a misunderstanding, or when a company has a misunderstanding about what the law may be in these areas. So, to talk a little bit about that and the role of enforcement in this process.
Right. So before we start to mix it up, this has been fun to watch, but I have to emphasize. Obviously, I'm just speaking as a staff person here, so just giving you my own impressions. So yeah, we do see situations where. I think what we're all agreeing here, not to further usurp your role as moderator, but I think we're all kind of agreeing like the holy grail for this area is really effective consumer choice. I don't know anybody who really says, oh, consumers should not have choice. Like, certain consumers, like children, may be protected. Their parents have to be informed and make choices for them about their privacy, but it is not a popular position to say consumers should not have a choice about sharing their data.
We'll leave that role to European regulators.
What there is, I think what everyone is very focused on now is figuring out, well, how do we communicate effectively with consumers and enable them to choose effectively in all these new types of environments like a mobile device, and make choices and information available for people who have different levels of interest and attention to give to these issues. So without falling prey to the privacy is a bummer kind of syndrome that Pam described. So I think the same challenge has confronted businesses. I think a lot of them are trying very hard to communicate effectively with consumers, but we do see situations where businesses put key information, what we would call in the context of an unfortunate complaint, naming a company, what we might say they failed to disclose adequately material information that they in fact did put. They think, they showed it to their lawyer or to somebody and they thought, hey, this is in our end user licensing agreement, it's in there, but we took a look at it and said, you really need to think about this from a consumer's perspective, because if a reasonable consumer wouldn't get this information that would have been important to them, that's deceptive. So when we do see quite a wide range of cases like that.
So, John, what do you have to say about
I actually am going to.
That's been offered.
So I talked about consumer choice, and Brendon, I think, converted that to consumer control. And I would actually disagree in the following sense. If and again, this is simple, I agree, but for the purposes of a discussion, if I'm building an app and I present you the app and I present you a clear information about what information I am collecting, what data I am collecting, what data I am sharing, that I'm taking it, I am selling it, I'm doing everything with it, and you say yes, that's cool. If you say no, then don't use the app. My point is that choice equals control, sometimes to say yes or no. It doesn't equal a buffet. So one of the interesting issues is, if I collect information and share it and use it for QC, or use it for improving version 2, or use it to sell it to data brokers, or use it to sell it to provide for more relevant advertising. There's a whole variety of reasons why I, as an app developer, might choose to collect information from my users. You, as the user, do not necessarily, some app developers may choose to offer it to you, but do not necessarily have the option of picking which information you're going to allow me to collect and which information you're going to allow me to share for which purposes. And so I would just say that choice might be just a blanket yes or no. Choice might be a buffet. The key is that you know that you have a choice. And then the hard part becomes what's effective communication. And that's why I go back to, and one of the things we've been working on with the consumer groups is location data. Collect it, yes, no. Share it, yes, no. With whom? Data brokers, Facebook, Pinterest, whatever, your friends. Your friends of friends. Your millions of friends that you met on Napster one day. Right? There's a whole lot of places we can go with that. But how do I effectively communicate that? And I think that's a big challenge. And I think we all agree, probably everybody up here, and probably everybody in the audience, that 12,000-word privacy policies are not effective. We now have a California law that requires privacy policies. Does that law help consumers? No. And I would say that to...
I got it.
It doesn't... Okay,
So-
it helps the one consumer out of 10,000 that reads the policy and
Look,
understands
I mean,
it.
a company, many times what I see and what we see looking at cases is companies did not do an inventory. They do not know what their privacy practices are. And I think a privacy policy gives a company an effective opportunity that they should welcome to figure out exactly what they do with information, what they collect, and what they do with it. So, you know, it may not be the sole or most effective tool for your average consumer, but it's an important step for a company to figure out what they're doing.
And my point was not about, is it good to have an internal process where you actually know what data you're collecting? Is it good to actually find a way to convey it?
Which does benefit consumers.
Having a privacy, and like I said, I'm a lawyer, but I'm not a privacy lawyer, right? And I haven't practiced in quite some time. But 2,000, 4,000, 6,000, 8,000 risk manager lawyers are doing their jobs when they write privacy policy. And I would make the case that 98% of privacy policies are written by risk manager lawyers, not communications specialists who are masters of effective communication. And that's the gap that we're trying to bridge. And that's why the law forces the lawyers to write the policy. And we're now trying to figure out ways to communicate what's actually happening.
I'd like to jump in on the point. I think communication is great. I think notice gets kind of a bad rap, but I think it's actually really important. I still think it's important. I think it's a building block of the fair information principles. I like it. If it's not there, it's a problem. If it's there, it gets reviled and mocked, which is fine. It's okay to mock notice. I've done it myself. But it needs to be there. Okay, so about choice. Okay, so this is another thing I have mocked before. The walkout opt-out was my favorite thing to mock. I think it was last year's FTC hearings. And okay, so you walk into a mall with a whole bunch of big box stores, and you go into a store and you see a sign that says, oh, by the way, we're taking your face print for facial recognition purposes, and oh, by the way, we're matching it, and we're data pending from census and from other sources, and we have your number, and oh, by the way, if you don't like it, you can leave. I don't think so. I think that...
Or wear a mask.
Right, wear a mask. That is not aesthetically pleasing. So, look, here's the deal. This is where we go back to gradation. I think we've got to figure out what's really important. What's important to focus on in terms of giving people rights to have control? Do we need to have control over every little bitty thing? No. And this is where I think, as privacy experts, we have to really look at this and go, okay, do we want to, stuff ourselves in a buffet, or do we want to, be more reasonable in our choices? So we have to make hard choices about what we care about. And to do that, I think we have to really listen to what consumers are telling us that they care about. And it's a whole range of things. Things like what's in their contact list, what's in their camera roll. They really care about this for a whole host of really good reasons. But we're living in an environment that's really turning into just an extraordinarily rich, sensor-rich environment. Everyone's got a camera. As soon as glasses come out with cameras on them, and I'm sure it's just a matter of time, it'll be really cool. I'm going to get a pair right away. It'll be really fun, and that's even more sensors. So we can't control that, right? So we can't opt out of everything. Given that we can't walk out of everything, what then is the policy choice, and what do we tell consumers to do? We can't walk out of our life. I hate that argument of, okay, just don't do it. I think that we should have our cake and eat it too. We should be able to have the technology and use it with some privacy controls and features. And this is where innovation is incredibly important. I think that really nifty tools can exist and be built into products that allow for this kind of innovation. When I hire contractors to do projects, I'm always intrigued by how they send me their social security numbers. It kind of tells me what kind of contractor they'll be. So on one end, I had a graphic artist. He called me, he said, 03. And then I got an email with 3 digits, and then another email sent like a couple days later with another couple digits. It was his SSN spaced out, and I'm like, okay. So then on the other side is one contractor sent me his SSN. I said, I need your information for tax purposes. He goes, oh, no problem. So he used share S, if you're familiar with that. When shares, it's share.es. And he sent it to me, and he said, oh, by the way, after you open it, it's going to self-destruct. So I opened his email, got his SSN. The email expired, and I thought, that's clever. That's the goal, I think. Having stuff like that really helps us meet these goals.
Snapchat and Facebook Poke have stepped in that area. I will engage with a couple of personal observations from experience in this area that I think may help in some of the discussion. You're reaching back first to the 2001 discussion around the California privacy policy requirement bill. Dana Mitchell's in the audience here tonight, who was involved in that fight and discussion, and I was involved in that on the behalf of a variety of clients. The ability to have a bright line, is there a privacy policy or not, with a limited set of requirements in it, has some value. But I certainly take the point, and I think it's definitely true that merely having a risk-laden, risk-protective privacy policy is certainly not an evolved practice, and it's certainly not an effective one. That we have to translate that into a meaningful dialogue with consumers about privacy. But having that bright line of is there a privacy policy or not is quite good. And John, you talked about the breach notification bill, which was also a companion bill of that year, which was a very interesting set of discussions. I recall saying to Joe Simidian, who was pushing the bill particularly aggressively at the time, we were in discussion about it, and Deirdre Mulligan from CDT, Jim's here tonight too, was very involved in those discussions. And I said to Joe, the industry, they might not fight you at the end of the day on the privacy policy requirement bill, but that's what they're going to fight you tooth and nail on. The financial services folks are going to be, go fight to the death, and you're probably not going to be able to get through. And then there was a security breach in the controller's office, which revealed all the legislators' social security numbers in their paychecks, and then it got passed pretty quickly. And so that's how you ended up with security breach legislation. But the other sort of major, I spent 4 years helping to craft the way that Facebook operated in terms of what I still think of as a privacy operating system. The ability to figure out with whom you're sharing at any given time. And it hasn't done it perfectly by any stretch of the imagination. The fact that a mass website would try to do that was a pretty major change. A bunch of the networks, social networks, tried to do this in an effective way, and Facebook was able to build this up over time. That, again, don't think it's been done perfectly, but the fact that it was done and that Facebook, the privacy turned from a binary, you either put something online, it's crawled, it's in a search engine forever, it's available, that's the way it's going to be, to you can share much more effectively outside of email. With a defined group and have even a feed structure that's based on those privacy settings, I still think was a pretty radical innovation and ended up, I think, driving a lot of the success of the company. So that need, that desire on the part of consumers continues to be, very strong, and how that dialogue happens is a critical path for companies going forward. So that's just what I throw into the mix there.
Can I offer a
Absolutely,
thought?
please,
Because just to follow on, there's a couple of things where interesting thought. First of all, I will concede that I did conflate choice and control, and another word, consent, is often conflated in this thing too. Choice and consent. Some of what you were describing sounded a bit more like consent, if it's a take it or leave it situation in particular. But there's another dimension that I think is really important here. We've kind of been, I think, alluding to situations where there is a direct relationship between the individual and the person collecting the information. And so there's some sort of user experience, whether it's an app, whether it's the retail store that you're walking into, whatever it may be. But there's a whole new class of data that's also rising fairly quickly, and Pam alluded to it. Sensor-driven data is one example. But there's also already on websites analytics going on behind the scenes. There's advertising going on behind the scenes, and there's data collection going on with all of these things. So there's a whole lot of data being collected where there's no meaningful user experience to even communicate directly. And if there was communication on all of that, it would be completely overwhelming to people, let alone reading the privacy statements of the first parties they go to, or even in the retail situation. You know, there's CCTV in a number of public places, and there's a sign that says, you know, something that there's cameras operating in here. But imagine if you had to then also portray what was happening with the information that was being collected through those cameras, and all of a sudden, how do you'd have privacy statements on billboards everywhere. So that leads to, I think, when this notice and choice, notice and consent thing we've been talking about a little bit starts to break down, and particularly as we fast forward to the future, where the world of big data and a sensor-driven world, where we need to think differently about this. And I think there's a lot of promise, it seems, and there's a lot of people starting to talk about maybe we need to focus more on the use and determine what expected uses are. I alluded to some of this earlier, what prohibited uses might be, and what happens in the middle in terms of deciding with the right combination of legislation and self-regulation and company practices, better understanding what people's expectations are, and delivering sort of safe privacy experiences, if we could say that, without having to burden people with notice and choice. So I just sort of throw that out there as something that's relevant to this discussion too.
Laura, you want to jump in?
Yeah, I agree that privacy notices, this seems to be a point around which a lot of people are coalescing in their beliefs. The privacy notices need to be streamlined. You don't have to, as we said in our privacy framework in March of 2012, you don't need to tell people when they order something that you're going to use their mailing address to deliver it to them. So the expected uses, you don't need to burden the privacy policy with those. But I guess I don't agree with the idea that consumers cannot possibly digest information about basic third-party sharing, like sharing with ad networks or other third parties who happen to have a presence on a website that you visit. I actually think consumers would be very interested to know and understand about how they're tracked across different websites by these players. So,
in the mobile, the NTIA document that we've been working on, one of the real difficulties we faced was controlling collection and then controlling use. It was a huge discussion over months. It was really challenging, and I think that there's a real watershed issue, which is third-party use. So basically, if an app is collecting, and I'm just going to focus it on apps because it makes it an easier conversation. If an app is collecting data, let's say it's a flashlight app or night sky app, they're collecting the data and they don't do anything with it. They don't sell it. They're just using it for either quality control or just they're not using it at all. That's really a whole different thing on the continuum than an app that exists solely to collect data and shuffle it off to a data broker. And those apps exist, and that's a real problem. There's a lot of fitness apps right now, and when I was at the Consumer Electronics Show, I interviewed a whole bunch of them just to figure out what their APIs were and who they were sharing them with and kind of what they were doing with their data. And there were so many of these data apps that were just, totally open APIs. They were sharing their data with all these third parties. And I was asking, okay, how is this data de-identified? And some of them had pretty good procedures and some of them didn't. So that's really problematic when data is going to a third party. So it's, again, going back to that continuum. I don't think there's a perfect solution to controlling collection or controlling use. They're both really hard. But I'll tell you what, if something's going to a third party, I do think it's a watershed. And I don't know that the choice can be binary anymore. That walkout, opt-out, I think is really challenging if something's going to a data broker, because then you come into eligibility decisions. If you're going to be denied insurance or employability, all of a sudden people care a lot, and there's real consequences. So it's, again, continuum.
These are challenging issues, and we've grappled internally with the App Developers Alliance and the consumer groups about how to manage them, and then as we sort of have enlarged the circle, grappled with others. And I would say the third-party issue is very interesting. If you're a small developer, you're not building your own ad network, you're not building your own analytics tools, you're outsourcing all of that. In comparison to a Microsoft or a Google or a more multiplexed company which does it internally. So is one worse than the other? No. Is one use different than the other? Not necessarily. Is one sharing with a third party? Absolutely. Is that a judgment? Not necessarily. And so we've grappled with that issue also. And it's hard.
To have that plug-in for those networks, there has to be a third-party sharing of information.
And I'm not saying there's a right or wrong answer. It's when we've come to a resolution at some interim point, and we're opening, and the discussion is broader. These are just interesting challenges that we're not trying to be judgmental. We're trying to communicate effectively about what's being done with your data.
So, and then how do we deal with that sort of bad actor problem, the data snarfing device, app that's just meant to operate? I had the same experience that Pam had in talking with folks at the Consumer Electronics Show. A friend of mine who's very privacy knowledgeable came back, and he had seen a monitoring device for a disease. I'll leave the disease unnamed. I don't want to be too particular at this point, but it it basically said that he quizzed them about what was going to happen with the data, how was it protected, and didn't get a decent answer in the bunch. They hadn't even thought about it. There's still a lot of that out there. How do you deal with that? I mean, enforcement actions are one opportunity, obviously, but how else?
Outreach is tremendously important, especially in this app area where developers can be very small, but suddenly reach just a very large number of consumers. So, apps can become popular very quickly, and as John has pointed out, a lot of them are understandably using code that was developed by someone else, and I think a real problem is that they may not know everything that code does, including the information that it's collected and who it's being shared with. And as we highlighted in our Marketing Your Mobile App Guidance piece, you are responsible for the code in your app. It doesn't matter that you didn't write it. You're putting your name on it and you're marketing it. And I think your group has been a responsible group for sharing that position. So I think outreach, I don't know what to say about a bad actor who may not be susceptible to outreach, but I think where you have small entities like app developers, outreach is very important. And I also think some of the initiatives that private groups and educational groups are doing to develop more privacy protective code to make those tools available are playing a really invaluable role as well.
One of the challenges about working with third parties, I think, came out in the COPPA rules. And one of our concerns about the new COPPA rules was traditionally, and again, Tim, if he was here, or some of you folks are much more deeply knowledgeable. My understanding is the traditional obligations of COPPA applied to people who collected information, and then arguably, who they were sharing it with and things like that. But essentially, it was about information collectors. And a lot of folks had built websites and built apps around creating great content. And they weren't in they didn't understand monetization, they didn't understand taxes, they didn't understand data analytics, they didn't understand how to do it well, optimization issues. So they found a third party. And they were able to use their content to attract small audiences or large audiences. And then with a third party, or multiple third parties, right, they did a revenue share deal. And every month the check showed up, and that's what they know. And they have an indemnification they have a contract that says, you, the third party, you are the information collector. You are responsible for complying with COPPA. I gather the audience, you monetize it, you collect, you follow the law. And that's been a healthy sort of partnership. I think it's fair to say that the commission is now taking a broader view of sort of it takes a village to enforce against each other, and sort of who's responsible for what, and who's if you will, who's on the hook. If you're serving up a partner's code and the partner isn't doing what they're supposed to be doing, who's responsible for it. And I think that's one of our concerns, is that a publisher who is merely a content provider with a door, if you will, with an access point to that data collector, is now responsible if that data collector screws up. And that's a really hard place for me to be. And I will tell you that we are very concerned that people who are in the business of creating really great content for kids and partnering on the monetization are now going to flee from the kids' business because they're going to be afraid if their partner screws up, they're on the hook. And that's a problem.
So Laura, how do we deal with
So
this?
I think, and I'm not entirely sure, I was racking my brain, did I read your comment? And I am not sure that I did. I do not work directly on COPPA issues, but I do a lot of outreach recently to app developers, including kids app developers, and so I need to be very familiar with COPPA. But so, one of the big issues with COPPA, and you can tell me if this speaks to what you're talking about, the revised rule will require a website that allows third parties like plugins to collect, so if it's a kids-directed site, and they allow third parties like a plugin, a button on the site to collect information from their visitors to their kid-directed site, they will be responsible if that sharing is not COPPA compliant. So for getting approval from a parent. Is that what you're talking about? That's an example of a kind of, and I mean, I agree, it's a difficult thing. It could change the business operations between these parties from what they have been, but it appears to be, and if you read the preamble to the final rule, it appears to be what's needed to get the job done, which is making sure that parents get information and get a chance to consent when information is collected from a child. So, and the person operating, the operator of the website is the person in the best position to carry out that legal requirement.
And we are, right, Google's a member of ours, CBS Interactive is a member, we have a lot of big companies. I think these sorts of rules, which create an advantage for the big company as compared to the small. And that's unfortunate, I think, for innovation and frankly for America.
Yeah, I mean, where you're sharing with, an affiliate or some bigger part of a large entity, I think, we're going to look at things like that. We always do from the perspective of a consumer. So if the sharing exceeds what a reasonable consumer would expect it to be, there may be an issue under the law anyway. So
great challenges in that area as well. So with that, I mean, we'd love to open it up to some questions from the audience and allow people to ask the panel and let us continue what I think has been a healthy discussion so far with a number of different perspectives, but driving towards, I think, a fairly common goal here. So why don't we start over here?
Thanks. The thing that bothers me as a user is on this side of the panel, I hear you telling me what you're going to do with my data, and on that side of the panel, I hear you telling me how you're going to protect me. Why aren't I ever asked? Where if you think about how a business works, your business, you've got a buyer and you've got a supplier. I'm your supplier. I'm supplying information. If I'm manufacturing a cog and my buyer wants to change the cog, I've got to talk to my supplier and talk about how I'm going to change that. Why do you never have a survey saying, we're thinking about doing this in 6 months, and open up to a vote? If I vote on something, even if my choice isn't the one that's chosen, I feel as though I participated. And I think that could help with a lot of these discussions. I'm sorry, so the question is, could you perhaps explain the ecosystem between the end user of the data that's buying the data from you, your company, and how you view the user in that system?
I'll take a stab at it. I'm not sure I'm completely answering it, but I think that you're posing the right question, which is how does the individual become a key part of the value chain here, and also a part of the decision process about what data is collected, how's it used. And I think we've talked about some of the potential pitfalls of over-notice and choice and all the rest of it. But what you seem to be alluding to as well is more research in some ways. And I think that many companies, and certainly ours, when we're increasingly thinking about privacy as a feature, just like any other feature. And when you're building a feature, what do? You try and understand what you think, what the customers want. Sometimes that's surveys. Other times you're trying to anticipate what you think they want and deliver for that need. And so I think all of those things really do go into decision making about, for example, what uses might be appropriate or not appropriate, what controls people might want and not want, what settings they might want available to them, what default setting makes sense. And so I think some of that is happening, and I know it is. It may not be obvious to people because it's traditional research methods and it's only subsets of the population and all those good things. But I think it's a really interesting development that I've seen, particularly in our organization, of how the business groups who are building the software and services and devices are very much thinking of it more like a feature, like anything else.
And on the law enforcement side of that, we are always looking for more information about how, so just looking at cases, we're always wanting to know how did consumers interpret this statement. Like before we allege in a complaint what a reasonable consumer would think a statement meant, we look for evidence. And among the very most valuable is, testing. Lots of times companies have done testing, and we very much want to see that. What did consumers that you showed this to think it meant? And we also use experts on our own testing to try to figure that out. And on the policy side, as equally, if not more so, we always are inviting researchers and others to present their work on how users interpret privacy policies and statements about privacy. So it's absolutely a very important part of what we do.
Look, privacy is a feature, not a bug. And the kind of thing you allude to would be just terrific if it could be operationalized. The problem is I don't know how you operationalize that. I mean, some of the models that exist right now for privacy, there's the EU model, the Data Privacy Directive. That wouldn't flow with what you're saying. And then there's kind of the APEC model, which also wouldn't flow. There's really not a model out there that would really, kind of go along those lines. I think the closest thing that we have is a law that came out in 1974, the Fair Credit Reporting Act, which actually gives us the right to have a lot of interaction with people who hold data about us, namely credit bureaus. So that gives you a lot of interactivity on the back end, but not on the front end. That would be, I think, a really amazing thing to build in. I think that would be a really good area to try things. I know Facebook had an iteration of that. I was really sorry to see that they stopped that. That would definitely be an application of what you're talking about. And one of the things that's annoying in privacy is that something will happen, there will be this giant press blow up, and people will talk about privacy for a while, but then it will die down until the next Exxon Valdez of privacy or Chernobyl of privacy, right? But in the middle is just all of us living our daily life wanting some kind of control or, effectual tools. And you have just everyday companies who are not necessarily communicating or asking you those questions. If companies could begin to innovate and say, okay, let's just throw it out to users and ask the questions, that would be the answer. Don't wait for a focus group, ask people. But of course, the liability, all the people in the company who are doing compliance and risk management liability are going to be really worried about that. So I think that would have to be balanced, but yeah, I think it's a good idea.
So next question.
Sure, you have risk management, but the reason it's an issue is because there's a lot of money to be made by capturing and identifying personal information. And you understand in the advertising business, some of the social media companies are struggling with making the business model work. So as long as there's a profit incentive, people are going to try and get more granular information about individuals. That's just going to continue. And if the technology continues to be smarter and smarter and smarter, so this is going to be an escalating problem because there's money there. So, when you look at the consumer, I work for Microsoft, and I'm a fairly educated consumer. But each application or app I download is set up differently. Each device I get, and there are new devices out constantly, is the UI set up differently. Can there be some kind of uniformity in the UI so you can look and find a uniform set of questions about privacy that are in the same place on each device and each application?
I want to respond to your first point and then answer your second, and then answer your question. Responding to your first point, I think the reason why we have as many privacy lawyers as we have rather than data use communicators is not because there's a profit motive, it's because there's plaintiffs' lawyers. And because the rule and the FTC has a very fair, I think, getting down to its essence of the FTC's deception rules, it's keep your promises. If you make a promise that you're only collecting X, then just collect X. And I think that's fair. And the problem is some companies, good, bad, small, and different, right? The product, the coder communicating to the product manager, communicating to the guys writing the privacy policy, there's a slip up somewhere in there, and for whatever reason. And there's plaintiffs' lawyers who go out and pursue it. I think the profit motive is all good. The question is, how do we effectively communicate? And that takes us to your question, which I think is what we've been working on very hard, which is how to bridge the gap between the 12,000-word privacy policy and the don't tell them anything and pick all the defaults for them, which is, what data are you collecting? Location, facial recognition, birth date, transaction information, financial information. Now, my friends at Intuit, and they're members of ours, would probably take the position, if you ask them, do they really need to tell you that in QuickBooks they're collecting your financial information? And the answer is probably no. But what's the harm? It's one line. It's financial information. Yes, of course they're collecting it. And Microsoft Money, does that still exist? I'm sorry. No. Okay, they were collecting it too. And that's fine. But if we can have 10 or 12 key words like that get you to the essence of what information is being collected, and then 10 or 12 key categories of who you're sharing it with, one of the challenges we've had in this process is, what's a data broker? Literally, we're saying, okay, we're sharing it with advertising networks. Okay, I understand what that means. Most people, if they're going to dig that deep into it, probably know what an ad network is. I'm sharing it for improving the product, right? So that when the next version comes out, we can understand where people have been and we're improving it. Everybody will understand what that means. What does data broker mean? And that's a challenge. But if we can pick 5, 10, 8, 12 pieces of information categories, 5, 8, 10, 12 pieces of who you're sharing it with, and standardize that. Not by law, hopefully it'll just happen because it happens because people are willing to do it and they're not afraid to do it. They're not afraid that by doing that, they're going to be under-promising or over-promising. That's a big issue about when we go to implement this. That, I think, is exactly what we're trying to do, to simplify, to consolidate, to give it to them in words they understand, and to be done with it.
I can absolutely answer your second question. That's what we wrote. And if it's right now, I would call on you to support the adoption of it, because that's where we are. The goal was to write something that allowed everyone to look at 100 different apps across platforms, across types of apps, and see the same quote-unquote nutritional label of information presented to them so they could make a comparison and a choice. And that's the model we built. That's what took almost a year to do. And that's what's before the NTIA right now. We welcome your support.
So let me be devil's advocate for just a second. There have been efforts in this area before that have failed. Why have they failed, and why is this going to succeed?
I have no idea where they failed. I'm new.
This is the first time. This is really the first time that you don't have either consumers locked in a room by themselves or industry locked in a room by themselves. We had a very challenging process where we could actually discuss, mature adults, the problems, and really, really hash out some solutions. And I think that's what makes it different.
I think that's a great answer. Can we have the next question, please?
So I have an issue with not believing that all the data that I provide is my data. at Microsoft, an app developer, they take great pains to control the distribution and access of the information they provide, the apps themselves, right? And I don't see why they don't take the same attitude around ownership, around my data, such that if I give data to somebody, it's my data. And if I slapped a copyright on it and put redistribution licensing on it, then I would know and be required to know who is using that and why. And I would not perhaps allow them to copy it willy-nilly and let it out into the wild.
So I think the question is,
And so the question is, aren't corporations being hypocritical in that they guard their own bits, but not of the consumers that they collect data from?
have you made the deal? Right? If I tell you effectively, this is the data I'm collecting, and these are the folks I'm sharing it with, and you say, yes, cool, I download the app. My premise is that you have now, you understand, and you have agreed, and that is the deal for the free app.
I don't agree, because...
Well, then don't download the app. Don't use it. Use a competitor. Pay for a different app that won't collect your data.
So you're saying that it's not a possibility that you would respect my data with the same rights you expect me to respect yours with.
But I think I just did. I respected your data when I told you what I was doing with it.
Sorry, because you said that you would be able to share the data, and I claim that sharing that data has released it into the wild, and that you should not be allowed to share it. It should have the same DRM protections that your software does, such that when you get my data, you don't get to just spread it around to whoever can hack into it.
Well, you got to talk to him about DRM. I don't know anything about that.
I think there's a number of interesting aspects to the question. I think that a part of it that I'll take is sort of a question of how can technology play a role to protect or ensure that the rules associated with the data, and some of those rules might be legal requirements, some of them might be the privacy policy that you agreed to. It might be specific choices that you've exercised around the data. How can technology be used to ensure that throughout the life cycle of that data that those rules are on it and that your rights around that are being protected? And I think that's actually a fertile ground for innovation. Because there is going to be so much information flowing around, and it's going to be hard to know what rules apply all the time. And I put that out as a challenge in some ways that this is a place for, I think, a lot of innovation.
I have to agree, because the other part of it is my information is valuable to some of the products, right? And I don't see why I have to see all that value to some middleware folks who are trying to collect it. Did everybody get the question there? It's like, my information is valuable. Whether I drive this kind of car, watch this kind of show, or whatever, that's information about me, and I should own it. And why can't I have the ability to do a direct to, bicycle supplier, they want to know, they want to pay me to read their advertising? Fine, I'll read their advertising. Or they want to know that I'm interested in that, and so I could put that up on, my social network page and say, pay me if you want to know this about it. Okay? That is actually, I think, the information economy that we need.
Yeah,
I absolutely control what my information has been created and where it goes and who's using it, and they're paying me if I want them to pay me.
Yeah, I think you're getting at there needs to be a value exchange for the use of data, and the individual needs to be receiving value. And I think that's ultimately what is happening with all of these great innovations that are coming along. There may be decisions that people make that they don't think they're getting the value for what they're giving up in the data. I would say one point about the notion of ownership of data. It's not always that absolute, because there may be joint rights in some ways. For example, with a bank in relationship, you can't necessarily say to the bank, I'm done with you, delete all my data. They have some other requirements to keep it and things like that. But so ownership can be I think rights might be a different sort of discussion.
Can we spend 2 minutes talking about data deletion? Because, no, honestly, this is...
I don't know, can we spend only 2 minutes talking about data deletion?
It's fascinating to me, and in our discussions with the consumer groups, there was a sort of... the point remained in the document, I think might still be in the document, that consumers have the option of data deletion or knowing what their rights are about data deletion. I have a technological question, though.
Actually, it wasn't even that much. And it was the most contentious statement in the entire document. All we wrote was this: if the company offers the right to delete, consumers will be informed. This nearly brought everything to a complete halt.
And by the way, I wasn't involved in that contentiousness. You know, that I staffed that with somebody else. But my real question is data deletion possible? Is it possible to delete any data? You can make it messy and make it allegedly inaccessible. But is it actually
drill through the hard drive and put,
I suppose putting a drill through the hard drive, but Akamai's not drilling their servers.
There's a continuum of deletion, for sure. How's that?
And it's an honest question, right?
That's an honest answer. There's a continuum of deletion.
Okay.
There is.
Because it's something that we do need to sort of make sure. I mean, regulators, legislators, and I don't mean regulators. There are some regulators, there clearly are some legislators, who believe that you delete the data by pulling the index card out of the file and throwing it away. And there needs to be an educated technological discussion about is that really even possible, and what does it mean when you sign off from when you no longer use a website and you want to actually back your data out or something. Right. What is capable, what is possible, what does it all mean, and what's the right nomenclature for that process?
Right. And what do consumers want out of that? When a consumer says delete, what do they want? And I think that's a really important thing to ascertain in different circumstances.
Let's just say that the dialogue on social networks around deactivation, deletion, everything else, has been a robust. There's a press cycle around it about every 12 to 18 months. So it's definitely going to continue. I'm sure about that.
I mean, that was one of our numerous counts in the Facebook complaint last year, was that by having a delete button, Facebook was promising users that their photos and videos couldn't be accessed anymore after they deleted or deactivated their accounts. But in fact, with fairly minimal steps, that content could still be accessed by other users. And we felt that that was contrary to what users would expect, and so that delete button became itself a deceptive promise. So I think that is kind of, we would look at it from the user's perspective, like what is their expectation, and has the company made them a promise about it?
And that's a situation where technological evolution sort of made that easier over time. Where,
yeah. I mean, and if you look at the order that Facebook has to comply with for the next 20 years, it's not that they have to delete information instantaneously. It's that they can't deceive about their ability to delete information. So if they say they can do it instantly and they can't, they're violating the law. But the absolute deletion requirement, if they say they're going to delete information, they've got to be able to do it in a reasonable amount of time, which is that's going to change that capability.
I'm sure that was a heavily negotiated point, something I was glad I didn't have to deal with since it happened after I left. So,
a lot of privacy policies changed. After that, I noticed I did a keyword search on deletion and privacy policies, and just all this new language popped up. Hedging deletion and what it meant. So I think that's still shaking down.
Yeah.
Okay, next question. Oh, do we have the next? Okay, question. Oh, where's our microphone?
I'm sorry,
okay,
I didn't realize I was up.
Hi. I run a company called Anchor Free. We make a very popular privacy app called Hotspot Shield. It's downloaded by about 100 million people around the world. And one thing that we see as an issue in the industry, and I'd love to ask the panel, is it's really easy for people to collect your data, right? If a consumer clicks a like button, that's all they have to do, and their data is collected. But privacy is something that's really hard, right? It's not, the people that are collecting your data, they're just asking you to click a button. The people that are trying to protect your privacy are asking you either to download really heavy software, 50 megs or something from an antivirus provider, or read a really long privacy policy, or even, if it's simplified and effective communication where it's 12 bullet points. 12 bullet points is a lot. If you look, I'm sure there's people in this room that have built products that have been used by a lot of people. When you build product, every little step the user takes, you lose 50, 60% of the users, right? You want the user to take 3 steps, you've lost 70% of your users by that time. So really, people that are collecting your data, our data, know this really well, right? They're effective at building products You click one button, your data's collected, you're done. People that are building privacy solutions, how do we make it that easy? Click one button and your privacy is protected. That's it.
But what does it mean to have your privacy protected? One of the things that we've talked about is that different people have different expectations. And it's, and it's going back to the copyright reference, right? Fair use is a transactional analysis based on what the content is, what you're using it for, what the marketplace is, and the four-step, and you could litigate yourself into a hole or write a research paper about it. And many people have. There is no such thing as simple privacy. And I think that's one of the great challenges we face. And so, with all due respect, if you want simple privacy, and you want to protect all of your own information, don't download apps, don't use the web, and that is an opt-out that you have as a choice.
Okay, so I take your point. What was the name of your app again? I'm sorry, I didn't catch it.
I love lighting fires.
Oh, okay. Okay, now I can hear you. Okay, so I take your point. And I mean, okay, so I have a PGP key and exactly 2 people have used it, right? That is not exactly, it may be pretty good privacy, but it's also pretty difficult privacy for most people. And I think your point is that, if I'm hearing you correctly, that it ought to be easier, and I agree. I agree. This is the convenience thing I was talking about. Innovation around privacy convenience would be terrific, and I think it's necessary too.
And I agree, it's a great goal, but one thing I don't want to lose sight of in all of this discussion is that we are not to the point where everyone has this supposedly overly cumbersome privacy policy. In our recent app survey, of the 400 apps that were surveyed, a small minority had any statements about privacy. And this isn't even just a privacy policy, this is an explanation of their practices in any of the accessible documents. So,
like United Airlines. And I bet they have a CPO.
Yeah. So next question over here.
Sorry. My name is Kashmir Hill. I cover privacy at Forbes. In a lot of these privacy discussions, we tend to assume the presence of a screen and a keyboard, and you have the opportunity to review a policy. But Pam started to get into this in terms of facial recognition and Google Glasses. Increasingly, with the Internet of Things and ubiquitous data collection, there's not going to be a screen that you interact with that you get to see and notice. So I'm just curious how you think how the system is going to evolve in terms of notifying people about data collection and asking them for their privacy choices.
Is it going to be like the Terminator pop-up screen if it's in the glasses where you have to read down your options?
Right, I mean, yeah. The thing that pops immediately into my mind from my own law enforcement perspective is, if there's this sort of one-way surveillance that's going on, a lot of people are going to be interested in that, not just civil law enforcers, but is the idea of like a material omission. Is there something about the information that's being collected from you as you walk into a store or visit a particular location that if you had known that would have made a difference in your decision to go there? And if so, not telling you could be a deceptive omission, or it could be unfair to you if it's likely to cause or causes you harm that you couldn't avoid because you didn't know.
If the mall puts smart dust on you and has a detection device in every store and records your track through the mall and doesn't disclose it, that would probably be seen as a deceptive practice by the FTC, I would guess.
and we haven't even touched upon law enforcement and drones and civil liberties and Jim Dempsey could probably and the EFF folks, Lee, and those guys could probably talk about that forever and ever. I was talking to the University of Washington. There's a technology and law clinic at the University of Washington Law School, and I always thought about that as sort of this stuff, right? Copyright, privacy policies, whatever. And he says, "Oh, we're talking to the mayor's office about how to help them do a drones information policy, information collection, and how long do you hang on to it for law enforcement reasons."
So I think where I come from with that question is sort of what I was alluding to before, is that there's not always going to be a user interface, particularly as we move to things that are this tiny that are collecting data that are on our person, or cameras that could be on the street as we walk outside, that sort of thing. And I think it does lead us back to this discussion about appropriate use. Because it's really hard to kind of communicate the collections going on. There needs to be somewhere a place where people are transparent, who own and deploy these technologies, do have a privacy statement, somewhere they can go. But it's not necessarily that the individual is going to interact with that in the moment that data is being collected. So first of all, they need a place to go to find out what's really happening. But then I think it's going to be a matter of how do we, as a society, ultimately decide what's appropriate, what's not appropriate, and how do industry sectors who are bringing these technologies forward work together on, codes of conduct, if you like, and which take a lot into account what consumer expectations are for this, set a bar that's reasonable so that the technology can ultimately be successful because it's trusted, and go forward with that. And then there'll be other ways, I think, to educate to people as to what's happening. I mean, I'm not sure about the drones. That's a little bit more challenging.
Yeah, I mean, another great analogy that's more in the present day for what you're talking about is data brokers that we mentioned earlier. So just assuming that they're parties that collect information about you, but not from you for marketing purposes, assuming not credit reporting agencies for now. There is no interface between you and these data brokers. So it's a very contemporary problem. How do we educate consumers about what information is being bought and sold about them and for what purposes? And it's this exact challenge of trying to find a place where consumers can go to learn things. And it's one of the things that we raised in our guide for businesses and policymakers report, is suggesting there should be data broker legislation. There needs to be a standard and perhaps access for consumers to, on a sliding scale, the information or types of information that these companies hold about them.
So we really support a page at the FTC as a central place on all data brokers. We've said that for years, so we really support that. To answer your question, so there's a really interesting kind of use case, right, in this area. Phil's Coffee, are you familiar with it? Okay, so Phil's Coffee, if you walk in with your smartphone on and with Wi-Fi on, what will happen is that an analytics firm will pull your signals and basically give Phil's statistics on how often you've been there over the course of a year, how many of Phil's locations, I believe there's 6 in the Bay Area, how you've visited, and how long you dwell or stay in those locations. So we actually have a forthcoming report. We went up to Phil's and we actually did a whole bunch of consumer interviews about what people thought about this, and they didn't really care, I have to tell you. It was really annoying to me personally. I'm like, wait, no, you've got to care. But the comments were really interesting. People told us, well, actually, we don't mind if Phil does it because they had a relationship with the coffee house, but we don't want anyone else to do this. And the thing that Phil's did that was so interesting is they have a physical sign in their stores that says, by the way, we're using a web analytics firm, go here for more information. If you go there, it's Euclid Elements. And you can opt out. You can just type in your MAC address, and you're not in there anymore. You know what? That's good. That's what should be happening.
If you can discover your MAC address.
They have directions for how to do that.
Yeah.
It's not the easiest opt-out, but you know what? It's excellent that they're telling people.
Yeah.
They're telling people in person. They're telling people on the web. And there is an opt-out. There's a whole lot of companies that are doing the same thing in other stores that don't even tell people it's happening and don't offer an opt-out. So I think that's a case of where something is really happening correctly. And that's a web analytics firm. And I just think that this kind of thing will be more ubiquitous in the future. How are we going to deal with all those signs? I don't know. I'd love to see innovation in this area too. Could there be pop-ups on our phone? How annoying would that be? I'm not sure what the answer is, but there has to be a solution somewhere.
So I think we have time for one more question. This gentleman's been waiting patiently for a while here. Oh wait, I think we can probably fit 2 more in.
Okay. I just wanted to make an observation and see what the panel thinks. It seems to me one of the biggest ironies about privacy, especially in e-commerce, is consumers aren't really aware of the value of their data. Those of us in the room here, we're all here for a reason. We know it's an issue. We understand it. But 99% of the world isn't really aware. But to the extent that that's true, and this is the response I'd like from you, it seems to me that's changing a little bit. They're beginning to realize that, the value of companies like Foursquare and Facebook, and they're having a better idea that there's not a magic box, there's something going on there, and all they're getting out of it is convenience, which is justifiable to some degree. But if you don't know what something is worth, then you're likely to sell it or give it away for minimal cost, they're free. So now that they're becoming more and more aware, and if you carry that through, I think that's going to cause that information change or that revolution that you guys had talked about earlier. Do you see that happening? Is that kind of, I think it's a positive thing, but do you see the momentum building? The consumers are becoming more frustrated. They think they're not getting the fair value exchange, to use a term you used earlier.
I instinctively feel that people are aware, people are expecting a rich value exchange, and if they don't feel they're getting it, they move on to something that does provide them more value. I think so, but I do think there's still people who really don't necessarily know what they're giving up as they use these services, and the research that we did and published today kind of underscores that in a way. People are not really sure what's going on there, and so that's an aspect here where it's hard for people to judge whether they're getting a fair value exchange because they don't know how much value is being derived from the data necessarily.
So, yep. Do we have time for one more? We've got time for one more question here.
Hi there. A lot of the discussion this evening has been around how privacy needs to evolve in a sort of technologically fueled world. One of the sort of key components to that, I think, is actually what we consider to be personal in the first place. And I'm a European privacy attorney, and so one of the questions that I sort of constantly grapple with for a lot of my clients is whether things like sort of cookie data or IP addresses or mobile device identifiers, whether we consider those things to be personal and whether they are things that are deserving of privacy protection. And I guess my question was, is that the correct way for things to evolve? And if so, how do you deal with those challenges?
You want to go first? Or you
Yeah,
want me to go?
I mean, sure. The FTC said a number of things on this exact issue that, over time, as these values are used as a proxy for your name to build a profile of you over time, they have become functionally, personally identifiable information. So in the privacy framework I mentioned earlier, we said if data can reasonably be linked to a specific consumer, computer, or other device, it is personally identifiable data. And the recent COPPA revisions, just as another example, incorporated persistent identifiers into the definition of personally identifiable information about kids if it's tracking you across different websites over time.
Yeah, I think laws need to define something, and that puts us into in some cases, falsehoods of defining something either as personal or not, and I'd rather think of it as a continuum of, each data element you've got to look at and assess what's the privacy risk associated with this. Because some of these things you can make an argument for or against as to whether they're personal. An IP address is a classic one. Yes, a static IP address that's, could be more easily connected to your identity, that sounds like it's more like personally identifiable information than perhaps a dynamic address that's turned over every, few days by an ISP and is not stored in certain ways. So for me, it's more about how do you assess the risk of the privacy risk associated with the data, and do you have commensurate controls in place to protect the privacy of that data, and do you communicate it correctly and all that. And then it also leads you to a discussion of how can I reduce the risk of that data through de-identification techniques and other things to move it down that spectrum from fully identified to fully anonymous, if there is such a thing, to reduce privacy risk while still getting value, still delivering value to the individual, but reducing the risk for the organization as who's the data handler. And so that's a more pragmatic way to perhaps think about it.
So if we can just take a second to wrap things up, that would be great. What would be your parting comment, John, for this discussion that we've had tonight?
I hope that
Can we just thank them for listening?
I hope that my machine is never considered personal, but this is hard. At the end of the day, I think that the most important thing, and I think what we've accomplished in the NTIA process, and I got to tell you, when the Department of Commerce first announced this multi-stakeholder consensus-based, bang my head against the wall, get 400 people in the room process, I thought to myself, and I said it to my colleagues, they have no enforcement authority. They have no authorizing statute. This is just doomed to failure. But what it did do was it got
other than that,
it got some people to join the coalition of the willing and to say, let's give it a shot. And I think that has been the most inspiring part of this is it got people into a room, and we can make progress. We don't need perfection is the enemy of the good, and sometimes perfection is the enemy of the very good. And to those on one side of the spectrum or the other who demand perfection, it's just not going to happen, especially in privacy. So let's figure out how to make improvements, consistently.
Yeah. Brendon? This topic's not going away. I think that we're only at the real beginning of data-driven innovation and the value that data can provide to, for economic value and societal value. And so it's absolutely crucial that we get this right. It is complex. I think the multi-stakeholder type dialogues are really crucial. And the challenge to us all is how do we better understand what people want as these new technologies come forward and try and make it simple. And I don't think that's easy, but that's the goal. Pam?
Okay, so this has been a great discussion. Thank you. Thank you, Karen. So I would say continuum. No black and white thinking. It's dangerous. It doesn't work in privacy. Control. It's really important for people to have rights. It's not about secrets anymore. A little bit about secrets, but it's not all about that. It's not about hiding from harms. It's about that a little bit, but it's about control and rights. And then convenience. Privacy is not a bummer. Let's find ways of embracing it as a feature, not a bug.
Laura?
I'm not going to summarize everything that I've already said earlier. You've been wonderful and patient to listen to us this long. But, we're going to continue to work in the four fronts that I mentioned earlier, are a key part of what we do in the privacy area. And we welcome your feedback. And I do just, say again, there's a lot of really basic work to be done in addition to tackling these tough and cutting-edge issues that we are also focusing on, too.
Well, thank you all for joining us tonight. This has been a robust discussion, and I think we've helped move the ball forward in a number of interesting ways on privacy. So thank you very much for having us. Karen, thank you.
I'd like to thank all our speakers one more time for sharing their perspectives so candidly. Thank you. And we do have for you a Churchill Club t-shirt, much coveted, speakers only, as a small token of our appreciation. You can wear it at the gym. You can wear it just about anywhere. And thanks again to our program partner and sponsor, Microsoft. If you want more information about our topic tonight, or if you didn't get a chance to watch the video that was playing during the reception, Microsoft has put together a number of pieces, including a new video series called Privacy in Action, that can assist you perhaps as you think about the collection of personal data online. Just visit Microsoft.com/yourprivacy, Y-O-U-R, privacy. A recording of this program will be available within a day or so on the Churchill Club website as well as on the Microsoft site, and you'll probably find it other places as well. So you've been an amazing audience. Thank you so much. See you next time.